I think it must be stated at the outset that we have cautioned this House and cautioned the nation of the abuse by the government of independent bodies and the judicial system, including the police, FICAC, even the DPP, and how this government has used these institutions to protect itself, to protect its personnel, instead of them being independent. That, in my view, Honorable Speaker, is not a democracy. That is fascism. It's tyrannical. It's dictatorship. And that is the shape and form of the country we live in and the government we live in, where there exists fascism, tyrannicalism, dictatorship, but we clothe ourselves with a parliament and with these institutions to show the world that we are democratic. And it must be stated at the outset that this is another way of the executive arm of government manipulating the judicial system. And it's said that we have, in this year, acknowledged the appointment of one of our members of this country to be the president of the human rights, when we are not living the principles of democracy, as I say. We are abusing human rights. We are doing all this. We are basically a dictatorship. But we have currently a person from this country who is the president of the Human Rights Commission. That's sad. And even very, very lately, we abuse again those human rights by sending Professor Pal away from Fiji. And even now, as we speak, there has been no statement from the Human Rights Commission locally, nor from from the local that hold the presidency. Now, if I can now turn to the proposed amendment, and noting here that there has been objections from many members of the public, including the Fiji Law Society, including also the Indigenous Lawyers Association to this, and with good reason. The role, the intention basically of this amendment is to threaten, is to intimidate those who oppose and criticize the government. That must be stated at the outset. And what the amendment does is that it seeks to amend the High Court Act by establishing a new division, which it calls the Anti-Corruption Division of the High Court. And before I touch that, let me just discuss first the process. Remembering, of course, Honorable Speaker, that how we process bill in this House is that we do so acknowledging, again, the principle of democracy, that the lawmaking process should be inclusive. But this amendment came on Monday under Standing Order 51. Standing Order 51 has the intention of denying the public, denying those who know, denying the experts their right to participate in the lawmaking process. And we passed it. And you can remember, Honorable Speaker, when this motion was put up for debate on Monday, we didn't stand up. I didn't stand up because it is a waste of time. We are sick and tired of this abuse. And I said, we are not a democracy. We are a dictatorship because we are abusing the very process of democracy. We are not living the value of democracy. And that's how it is here. That's how it is here. We have denied all these people their right to participate. That's the reason why the Law Society is writing. That's the reason why the whole public are complaining. So here we are at this stage, and we are being given 1 hour to debate this. And now, let me go to the intricacies of this amendment. That is basically what this amendment is seeking to do. So that soon after this, all the cases that are current there, including ours, there are 6 of us who are now also part of that, will be channeled to a single court. And that is where the interference that I'm saying with the judiciary, with the judicial system. And I'm sure it will even extend to even interfering with the judicial personnel as well. Because once you have that, the government will be assured that all these people will be intimidated. That no one will stand up and criticize the government. That no one will stand up something that democracy guarantees. And there's something wrong here, Honorable Speaker. It says the anti-corruption division of the High Court. It will not be the anti-corruption division, because if you look at the jurisdiction, it will not be just charges for corruption. It will include all proceedings that are started by FICAC, even if it starts with a criminal charges. So it is wrong to say that it will be limited to corruption. It basically means we'll have totally a FICAC court. Now, the Honorable Attorney General justifies himself that this will be a specialized court and it's common overseas. It's wrong. Specialist courts usually are determined by the volume. That's why we have the family court. That's why we have the tax court. And there's another court they have not included here, which is the agricultural tribunal. And we usually do that where we have large volumes of cases that requires speciality. That's not the case here. We don't have that much cases, or FICAC cases, that will justify spending billions of dollars or a very substantial amount to establish a special court by itself. So he is wrong on that. Another point that he says is consistency of application of the principles of jurisprudence. Again, wrong. We have the appellate jurisdiction of the High Court to do exactly that. This judge can make his own interpretation. That other judge can make his own interpretation. But consistency will come from the right of appeal. And that's the very reason why we appeal. You appeal so that the appellate court can see to that consistency. So the Honorable Attorney General is wrong on that point. Then he says, there's another point that he said, is certainty. And he says, we are doing this because it allows judges to know exactly what is the law and the tariff. Again, totally wrong. That is the reason why we have the appellate jurisdiction for that. But the motive is clear, Honorable Speaker. The motive is very, very clear. This government is interfering with the separation of power. And we have stated that before. It is interfering with the judiciary. It is interfering even with the legislature. We know that, but we are not mentioning it. And this is another. So it is using this. It is manipulating the court system so that it will threaten, it will intimidate those that oppose it, those that criticize. That is the very reason. And we need to change this government. We need to change it. We need to remove it. There are two ways that I'm told. One is the way they came in, for the army to come in, but I'm not going to talk about that. The other way that I wish to recommend to the people is by election. We have next year to the election. And we have suffered enough by the abuse and the mismanagement of this government. The whole country, the individual, has suffered enough. We have had enough. And I recommend every individual, please, next year, when you go to the vote, remove this government. They have destroyed the economy. And now they are manipulating the judicial system for the very reason to keep them there. For a very reason to threaten, to intimidate. They have done that. FICAC and other constitutional established independent bodies are not independent. And the sad thing for us is that we cannot rely on our friends on the UN to help us. The US will not help us. New Zealand will not help us. Australia will not help us. We have to rely on ourselves. And the only legal way that is there before us is to vote. And I beg everyone, please, vote this government out.
I thank the Honourable Nikon Waikula for his contribution to debate. I'll take the Honourable Fires Koya, and then I'll take the Honourable Wanganika. You have the floor, sir.
Thank you, Honourable Speaker, sir. Honourable Speaker, sir, I find it quite rich that someone who's been a part of some anti-democratic